that you don't want to see their mother again until she's in a casket, sir. Do you want that to happen?
Well, it was out of frustration and anger in the first
Yeah, that
months
shows
after I
me
got divorced.
your actions.
When this therapy session ended, came running out, ran up to Dylan and said, "I did what you told me to do, Daddy." And he said, "Good job."
Good afternoon. This is the time set for case D 21635-772D. We have everyone in the courtroom. You want to start with Ms. Houston, you want to make your appearance, please?
Dylan Houston, bar number 13697, pro se.
Good afternoon, Your Honor. Dana Dwiggins on behalf of Paul and Julie Page, who are present with me. Lexi Page is also present in the courtroom, and then Ross Evans from my office is participating by Zoom.
Great. And let's get Mr. Evans. Can we get your bar number, please?
Yes, Your Honor, 11374.
Thank you.
And I'm sorry, mine's 7049.
Say that again?
7049. I
Okay.
always forget to say it.
All right. So it is the Page's motion. So why don't you go, if you make your argument, and then I'll let Ms. Houston respond. I have read everything, so I don't need you to repeat what's in there.
Have you seen the video as well, Your Honor?
I have not watched the video.
It was sent to your.
Yeah, it was, and I haven't watched it.
Okay. I would obviously request that you watch it because I do find it kind of disturbing. As far as what Mr. Houston has his children doing to participate. We obviously quoted it in our briefing. I'm not going to reiterate what's in our briefing. We find it very disturbing how his behavior escalated after the hearing we were in front of you 2 weeks ago, and how it continued until we ended up filing this motion. I think it's inappropriate. He's not acting in the best interest of the children. Again, I find it disgusting what he did to the children and forced them, for a lack of better words, to do. I know in response, he states that it was geared towards Penny Fife. However, if you read the text messages, both before and after the video, there is nothing in there at all to indicate that it is geared towards Penny Fife rather than my clients. What I've been informed is, even though he did take them to see Penny Fife on Thursday as ordered by the court, I had a phone call with Miss Fife, who expressed extreme concern for the behavior of the children during the therapy session, and that the majority of it was spent the children and or at least disrupting her office, trying to throw things, acting in a behavior that is very consistent with her actions in the video, that resulted in less than a meaningful session at all. Ms. Fife expressed concern that she had never seen Emma act in that manner, and that for all purposes, the therapy session was non-existent. She has expressed concern over Dylan's behavior and intimidation of her and his actions towards her that make her feel unsafe. He has made clear to this court that he does not want the children to see her any longer. And despite the agreement and this court's order stating that at a minimum, she will see him to the end of the year, it's clear he is trying to circumvent this court's order by intentionally acting in a manner that is trying to get her to terminate her therapy sessions with the children, or so that they have no important meaning. We are very troubled by that. Not only that, Your Honor, I think his opposition doesn't really go to the merits of our motion much at all. I do find it very concerning that despite your admonishment to him last time about submitting sworn declarations to this court, that he nonetheless submits another one with, for a lack of better words, a statement that, as a matter of fact, that my clients caused these, quote, death threats to be made to him, which I think the word death threat is quite the hyperbole, But my clients had no involvement, no knowledge or anything, yet he swears under oath that it in fact was my client's. He's an officer of the court as an attorney. We find that troublesome, especially after you previously admonished him. I think it's clear his actions are not acting in the best interest of the children. He's trying to alienate them further from the interveners. And we ask that this court stop those actions before they escalate even more. Unfortunately, I think what he did is going to result in more therapy to the children because of the confusion, his misrepresentations. I mean, my name's been brought into it. As far as I'm trying to keep the children, there's statements that he has his daughter stating that we have tried to keep her from her little brother, which is not accurate in any means whatsoever. I just think that this court should see his actions for what they are. I think this is how should I say this? Basically a repeat of what his actions were in the court prior to this. And unless this court reins him in, he's going to continue doing it because he never saw any consequences before. The children's best interest is what is to be the focus. And I don't know how he could sit here and say to the court with a straight face that he is acting in their best interest. So we requested a behavioral order. That too, I think his contact with Miss Fife be very limited and that he stop intimidating her, threatening her, as he indicated in even the text messages that he sent. He wants to sue her for negligence. He's gone to the DA's office to report her for perjury. He is going to report her to the licensing board. And for what purpose other than he doesn't like her? And I think it's inappropriate. It undermines this court's order and what's in the best interest of the children. He is putting her in a position where she feels intimidated and concerned for her own safety. And we ask the court award us attorney's fees, impose sanctions upon him, and rein him in. And we think he is in contempt of these prior court orders. I do think I do think this court should watch the video because his actions during the therapy session, the video was provided to Ms. Fife ahead of time to potentially address any behavior stemming from that, which according to her, behavior during the therapy session mimicked what was done in that video and what Dylan rehearsed with his daughter. And not only that, Your Honor, Ms. Fife told me that when this therapy session ended, came running out, ran up to Dylan and said, "I did what you told me to do, Daddy." And he said, "Good job." And I don't know if Your Honor has any other questions, but.
All right.
Your Honor, as far as any statements they're making on behalf of Dr. Fife, it's clear that they've worked with Dr. Fife. She's admitted she's speaking to her. They could get another declaration if any of that was true. They shouldn't rely on hearsay or any of these statements. And their argument is essentially two-sided. Somehow the video is both about the interveners, but also consistent with the therapy session. Obviously, my position is that nothing to do with the interveners. And if they're arguing it's consistent with what in this therapy session, I think that supports the position that it had nothing to do with the interveners in the first place. Certainly the messages I've received, I've had my car broken into, but nothing stolen, things of that nature. I certainly believe that someone is sending these messages to me on their behalf, an agent, a friend, whatever it is. And that's very reasonable. Who else has advanced that position on national television and in this same courtroom? It's consistent with the positions they've taken. It's almost verbatim the things that they have advanced in this case. I mean, what's good for the goose is good for the gander. I don't know how they can have discussions with my children about, the murder things that were on the internet, and this court said, hey, full disclosure is good. Okay, well, when they see the press conference, that's somehow off limits, and they're not allowed to hear the intervener's own statements about their dad, which not only implied that I was involved with the murder, by reading old text messages that were years old. It certainly made statements that Paul Page always thought I would hurt his daughter. There's no evidence of anything like that. So if they don't like what was happening, they shouldn't have been showing, or they shouldn't have been discussing these topics with my children, and then they don't like what I discuss with them. It's essentially the same thing. I can foresee, and this has happened throughout this case prior to the intervention, is if I do something, it's not allowed. If they do it, it's certainly okay. That was Ashley's position throughout this litigation, and it's going to continue to be their position. And if we get into these behavior orders, I think I've addressed them line by line in the opposition, but we're just inviting dozens, if not hundreds, of motions to be filed in the future. I also think it's important to note that what they omit in there, and I was admonished by this court for omitting a text message. Well, they did the same thing in their motion, which showed I complied with this court's order. And it was Miss Fife who said, oh no, I'm not available till October, when I said I consent, and I'll be bringing them for therapy to transition to the new therapist till the end of the year.
Your Honor, just briefly in front of that, if you read the text messages, she said she needs to check her calendar. She didn't have it in front of her.
But, it's interveners exhibit 2, the text messages, and then put them up on this.
And then it's interveners motions exhibit 5, or oh, sorry, I thought we were talking about the therapist messages.
No, I'm not talking about the therapist now. Go down past the video. Right there, leave it there. It's very disappointing that you guys back in court so soon. And coming to court and the court's abilities is limited to fix some of these problems. It's not going to fix the real problem in this case. My ability to enforce orders and to make orders are pieces of paper. It doesn't change the underlying problems here. And you guys can keep escalating if you want. Both sides can keep throwing things. Wait till they get older, and then they can show them your text messages where you say that you don't want to see their mother again until she's in a casket, sir. Do you want that to happen?
Well, it was out of frustration and anger in the first
Yeah, that
months
showed
after I
me
got divorced.
your actions right after the hearing. That night you went home and said, oh, I'm gonna use my children as a weapon to hit the Pages over the head with. Without regard to their well-being, without regard to their emotions and how young they are. Nobody went and told your children that use the word murder. Your kids don't understand at 5 and 7 what the word murder is and what that means. They were told a very limited information, and then you thought it was good, so let's up the ante. And where you go on to say next. Tomorrow's lesson, that's there, up there. Tomorrow's lesson is if Mima and Papa, that's where you admit those referring to the Pages, right?
Correct.
Didn't undervalue and underpay Mom so much, they would have made her a partner in the family business. If they did that, she wouldn't have had to marry a grandpa 27 years older than her, because she would have had more money than Dad, and all her dreams would have come true. That shows exactly what you're trying to do. You're using your children as a weapon.
It's not as a weapon, it's really just an understanding of how, if they had
But you
valued
understand
Ashley.
that you both sides can keep escalating that. There are certain things you don't like that the Pages have done in the past. There's many things that they don't like that you've done in the past. But your children are 5 and 7, and they have their own constitutional rights. They have the right to be safe, to not be abused physically or emotionally. They have the right to have a relationship and love you and to love their mother. They have the right to have a relationship with all the extended family. They've got a lot of extended family on both sides. I don't know for sure, because I wasn't the judge at the time, but I know you have many sisters. because they were involved in supervising your visits when they were under supervision.
7 siblings.
I know you have your mom. I'm sure that they love your mom. They love the Pages. They love their little sister. They're entitled to have those relationships and they're entitled not to be used as weapons. And I wouldn't let the Pages do that either. I'm not gonna let them sit and show your kids your text messages to their mom when they're old enough to understand what those words mean. That's not appropriate. It's the truth, but it's not appropriate for those children. Do you want them to do that? Do you want to keep escalating this back and forth?
Well, no, but my understanding of the court's ruling is if it's available on the internet, which those text messages are, because they've read them and disclosed them to the media, then they're gonna see them one day. So I explained them on the front end, which they read those messages in the press conference. And I explained
Did your kids need to see that?
the press conference.
Yeah.
They did, according, because I needed to tell them that this is what happened after. Dad was accused of being involved in this and he wasn't. And do you guys think I was involved? And obviously they said no.
All right, this court has exclusive continuing jurisdiction over matters related to the custody and care of the parties, 2 minor children. We're only 5 and 7. The parties were last before the court on August 25th, 2025, on Dad's motion to modify the last custody order. Orders were made clarifying regarding the children's counseling, but a written order is still not entered from that hearing. The last custody order is the stipulation and order entered on January 30th, 2025, by which plaintiff dad agreed to give certain rights to interveners, maternal grandparents, to settle the disputed claims that were before the court at that time. These agreements, which were made orders of the court, include, among other things, that dad and maternal grandparents currently share joint physical custody on a week-on, week-off schedule, and that the children would continue counseling with Penny Fife. Maternal grandparents have filed a motion claiming that immediately after the hearing on August 25th, 2025, violated the stipulation and order regarding counseling with Ms. Fife and regarding communication with them in a respectful manner. That's the stipulation and order specifically states, and that's the order that's entered and the parties are on notice of, states that paragraph 15 on page 5, all material communications between the parties regarding the minor children shall be conducted in writing, and the parties shall communicate in a respectful manner towards each other. Maternal grandparents have made a prima facie case, and the affidavit, the declaration of counsel complies with AWOD in terms of the details. So I could set an evidentiary hearing on their request to hold you in contempt of that provision. They also claim your contempt regarding your attempts to interfere with their therapy with Ms. Fife. I could set an evidentiary hearing. I've got dates available to do that. It's their burden to prove. If you're asking for criminal sanctions, it would be beyond a reasonable doubt. All the elements of contempt. I'm not recommending that. You made a prima facie case, but the more you guys come to court, the more this is going to escalate, and the more these 2 children are going to be hurt. I want to make effective orders, effective in terms of not making the situation worse. It's already a bad situation. There's already a lot of feelings on both sides of hurt, anger, disappointment, all those feelings, but these children should be shielded from all that as much as we can. You know, the fact that it's not good for children to believe, particularly I'm talking about your daughter, who's 7, to believe that her mom died in a car accident, because when she finds out later that that's not the truth, she's not going to believe any of you. She's going to say, all these people have been lying to me.
Well, that was never said by me, obviously.
I've never said you said it, but that was her belief. That's what Ms. Fife said her belief was, because she wasn't given the information, and it should be given to them in a manner that is consistent with their developmental, their understanding. They're really young to understand concepts of murder, suicide, those words and what they mean. They're too young to understand that big words, but in the way Ms. Fife recommended it be said that they were hurt, and they all 3 were hurt, and they're all not with us anymore. That's something that in their terms that they can handle. Nobody said to go out and tell them that there was a years of custody litigation between their mom and dad, where lots of accusations were made, where some accusations were proven true with clear evidence. Do you want them to know that you tested positive for cocaine, sir?
I'm sure they will
No,
know
it's
about
not
that.
appropriate to
It's-
tell them, and I wouldn't, I'm gonna make a mutual behavior order here that's tailored to this case. I wanna de-escalate things, but you can't use your children as weapons. You have constitutional rights, yes, you have First Amendment right. You have a constitutional right to raise your children. Those rights are not without limits, though. They are limited, first of all, when they butt up against other people's rights, your children's rights not to be emotionally abused, for one. Also because you stipulated the pages now have rights because of your stipulation. So your rights as the sole parent are not unhampered. And like I said, I'm not, they have certain feelings, the pages have certain feelings about how all this went down and the cause of their daughter's death that I'm not gonna change their minds about, you're not gonna change their minds about, but I'm not gonna let them tell your children that way. I'm not gonna let them watch depositions or read, there was a lot of stuff in the litigation. Watch the videos of you that were taken by the PI. That's not something they need to see. I'm not gonna let them show them, and the rules clearly state that in EDCR 5 point. That they keep changing the numbers on us. 5.301, that you're not to discuss any court issues or show them pleadings, show them evidence that's in that. You're supposed to shield your children.
Well, none of
And
that,
and they should shield their grandchildren from these adult issues. I'm not saying that you're alone, you're just the one whose behavior is before me
but none
today.
of that was done, and this video predated them intervening in this case. The press conference, they were not interveners at that time, so they weren't.
I
parties.
understand that. See, I don't, as I said, and I said to you before, the behavior that you did as somebody who is, what are you, how old are you now?
36.
Okay, you're in your 30s. You're not only college educated, you have a law degree, you have a law license. And the fact that you can't stop yourself from creating evidence that makes you look bad means to me there's definitely a lack of maturity, there's a lack of self-awareness, and there's a lack of impulse control. You not only went and did this to your children, but you sent them text messages saying like, I'm proud I did this to them.
Well, I don't try to hide and obfuscate the things like
Well,
they do.
and I will go back to what I recommended to you before. You should be the healthiest parent you can be for your children, and that includes getting therapy and working on your weaknesses. Because we all have them as people and as parents. Work on them because you should know better than to create this evidence. But you still, you're back to where you were when you were sending all these text messages that you shouldn't have put those thoughts in writing. They make you look bad. There's no other way around that. So do your clients want to actually go forward with a contempt? Because I will do it. That's my job, but it's not what I want to do. I don't think it's gonna make anything better. I don't think it's gonna change dad's behaviors. I don't know what is gonna change his behaviors. I have to understand myself that there's a limit to what the court can do to change parties' behaviors. I can try to make you see that what you're doing is not in the best interest of these two children, but I'm not there with you in your house. I can't control the things you say or how you say them to your children. Your children are very smart. I'm sure they knew when litigation was going on that at least they knew mom and dad wasn't getting along. They knew that there was changes in their contact with you. They weren't oblivious to those things, but I want to try to shield them and I want you to do that. Like I said, the bigger concern for the court is these two children are being used as tools for revenge without any regard for their feelings or their rights. And frankly, I think this is emotional abuse.
I think we're gonna be back here very shortly on emotion of my own, because this happens every Monday when I get the kids back, that there's a clear pattern that something is going on in their household because there's a lack of emotional connection to myself, my girlfriend, their little brother, until we have them for a day or two, and their behavior is completely changed every Monday night.
And you should definitely talk to some experienced children's therapy, because I have been doing this almost 30 years. That is a typical complaint I hear parents when they're going back and forth, whether they're between parents or between a parent and grandparents. Children take time to adjust, especially they know you guys don't like each other. They know that. They know you don't like their grandparents. They know that their grandparents don't like you. They know that their mom was involved in disputes with you. They're not totally unaware of these things. You got to shield them as much as you can from that. So
Your Honor,
Excellent question.
I'll represent, my clients don't talk about Dylan in a negative manner at all. And you could put one or both of them under oath right now. They state that he keeps that household separate and distinct. They don't intrude. They respect her boundaries. As you said, she knows of the lack of relationship, for lack of better words, between the two, and she keeps them separate. The fact that it takes time to adjust has nothing to do with any actions of my client. They've done nothing but provided a loving home environment for the children. They have not responded in a negative way or engaged Dylan in any of these text messages or any of the behavior. They just want it to stop. They have the best interest of the children in mind. They want them to heal. They want them to grow and be safe. And they want Dylan to stop doing what he's doing. He is clearly, as you stated, acting on emotion, anger, whatever the case may be, but it's not in their best interest, and he's doing more harm than he is good to them.
like I said, I can't control anybody's behavior outside this courtroom. I can write orders, I can enforce them to the extent the law allows me to. But I can't change your behavior. I have to get you guys to buy into the fact that you need to shield your children from that. They need to shield from their views, that they need to go get counseling on their own. Their daughter was murdered. There's no way around that. They have feelings about that. They have feelings about how that happened and who was responsible for that. But they've got to, and I will make them, because I can control their visitation, make them shield their grandchildren from those feelings. Those are things that they should discuss with their own therapists. They should discuss with the adults when the children aren't around, because they overhear things. Even if you don't mean them to, they will overhear things. I can't change that. I can't change that. You have feelings about them and their contributions to the long-term litigation you guys were involved in. And I can't make you change those, and I would, but you definitely have lots of adult family members and friends to talk to about those things. You can talk to your counselor about them and how to work through that. What you need, none of you are going to do is use these children as tools without me at least trying to do something about it. So if they want to, the problem is, if I find him in contempt, and I do use my authority to sanction him for that contempt. Is that going to make it better or worse? Is it going to deter further behavior from him? I don't know. That's why I
You
caution.
know, obviously, I would like an opportunity to talk to my clients. I mean, the initial inclination and all candidness is not to proceed, but something has to be done to stop him. Because there was no consequences to him before, and there's got to be consequences now.
You could
There-
say the
there
same
were
thing
some
about Ashley's
consequences.
behavior. I could say the same thing about them lying to me about how we were gonna handle the last situation involving discussion with the kids. So this is, as always, it's not a one-way street.
No, and I'm not saying it is. We're
He
here
is
on your
not-
behavior because they filed a motion specifically on that. But I'm saying these things in general about the big picture, that these two kids need to be protected as much as possible. I can't undo the tragedy that's happened to them. They're gonna have to live with that. I can say they need counseling, and let's give them all the tools we can to help them process the tragic loss.
And
And
he's
they're
in
gonna need more counseling as they get older and understand the exact situation. They're gonna have feelings about that once they're old enough to understand all the adult situations that happened that got them there. And they don't understand murder and suicide now, but they're going to someday, and they'll need therapy then too, once they understand that. But we can shield them. The more you guys come to court, the more there's gonna be hard feelings, the more that the kids are gonna pick up on these hard feelings, the more orders I have to make, the more resentment everybody's gonna have. I don't wanna make the situation worse. How do we make it better, Mr. Houston?
Well, that's my concern with this order. If granted and all these behavior conditions, it's gonna turn into dozens or hundreds of motions like prior to them intervening in this case about conduct based on, oh, the kid said this and now we have to file a motion. It's just gonna be never ending. So I don't think any of this is warranted based on these messages.
Your Honor,
But that didn't answer, hold on, that didn't answer my question. How do we make this better? So you stop upping the ante, for lack of a better word. That's your words. Tomorrow's lesson. So you're gonna up the ante even more. That shows lack of maturity and lack of care for your children. How are you going to?
Well, I
protect
was the
them?
one trying to shield them initially from these discussions. It
And
was them, they
the
wanted all
pages
this,
didn't agree.
they wanted all this out in the open and
You're not
now they're
listening.
complaining.
The pages didn't agree with that. They wanted them protected too. All three of you, first instinct was to do that. And Ms. Fife made good points about that. There's downsides, there's consequences to them not knowing the truth. And what the truth that they're capable of understanding this day.
And then if
There's
you recall, they
consequences
said
to
they
you.
would let me tell my own children and then they didn't. They lied to me
Well,
about
you
that.
said you were
The
going to.
court found that there was justification, but what they said was that they agreed I could tell them alone and then they went behind my back and told them. That's how it played out. The court found
And you agreed
justification for that action based on my text message, so it didn't change their visitation, but that doesn't change how I feel about them lying to me about it.
Your Honor, just listen to him. He has an excuse. There is no accountability on his part. He thinks it's appropriate to let them watch a press conference. He thinks it's appropriate to, God knows how many times he rehearsed this video with his daughter before he did it. He thinks it's a joke. And I invite you, I will give you my phone for a minute for you to watch this video because it is so disturbing. Emma had trust and confidence in Penny. And he's probably destroyed that now.
And I get their frustration, and I mean, Mr. Houston, I have to be honest with you, I do see your behaviors as trying to undermine their therapy. You don't have to like Ms. Fife, but you do have to not, you agreed to her continuing. That was a part of the whole global settlement.
And as part of my opposition, I showed where I did exactly what the court ordered.
Okay,
She
and-
was the one that said,
And that's, you can do what the court's ordered and still subtly undermine the therapy so that
well,
it's a
I
waste
do
of
have a
time.
problem. I think she's breached her confidentiality duty and we're having admissions in court about how there's constant communication between interveners counsel and Dr. Fife. I don't think that's proper.
She has not discussed what she's discussed with me. She just told me that what occurred as far as not being able to give therapy because she was destroying the office and basically mimicking what was in the video that was rehearsed and then going out saying, Daddy, I told you to do exactly what you told me to do. And he says, good girl.
That's hearsay and she can come in and testify to that if she wants to, or
And do
submit a declaration.
I don't want to get into this. I want the behavior to stop so your children can.
Well, I only have 2 more appointments with Dr. Fife. I'll never see her again after that, so I don't think there's an issue there.
But you don't have to intentionally try to undermine your children's therapeutic relationship. They need the therapy, regardless of what all the adults are doing.
I agree,
Your
but I
children.
want a therapist that hasn't been tainted by discussions with counsel.
I
predating
understand, and
the settlement.
I did grant you
I
those.
understand
There's a
it, so
process.
I'm excited to move on to that portion.
And everything is speculation on his point. He states everything as a matter of fact without any type of evidence.
Okay. And he can argue the same thing. We can argue, we can keep coming back to court, we can keep doing this. I don't, my experience, 30 years says that's not gonna help these children.
I would agree with that.
You can't continue doing what you're doing, though. If you think that this is okay and it doesn't make you look bad, you need to get some counseling yourself to see that you're not aware of how you come across. You're not aware of how damaging this can be to your children. So I am gonna enter a mutual behavior order, and it's gonna be mutual, and it's going to be because I want to protect these children. That's all of our jobs as adults, to protect them from the harsh realities of life until they're older to handle it. So they have tools through counseling to help them handle the harsh truths that are part of their life already. So what is going to be there is, I'm gonna give you the exact terms so you can incorporate it all in. There should be no threatening, intimidating, or harassment of Penny Fife. If you don't agree with her, you think you have a legal thing, I agree with you that you have a right to proceed with those things. You don't have a right to try to intimidate her or harass her or threaten her so that she doesn't continue the counseling until when it changes as I've ordered. And that's mutual. None of the parties shall communicate with the children about Ms. Fife in a disparaging manner. There shall be no threatening, intimidating, or harassing the other party or their counsel. There'll be no abusive contact, including foul language or name calling, including telephone calls, voicemails, letters, emails, texts, all forms of social media, etc., to the other party or to the children. No unnecessary contact with other people associated with or to the other party for the purposes of discussing court proceedings or making negative, disparaging allegations against the other party. This includes all forms of social media. You will advise all of your friends, relatives, and significant other not to disparage, criticize, harass, or threaten the other party. So if those threatening messages Dad received came from someone on behalf of the Pages, that's not helpful. That will hurt these children too. If something happens, they love their dad. And they need to be able to be children and love their dad. So that's going to be part of the order. No harassment at the other party's place of employment, including contacting the employer to make negative or disparaging allegations, or to send or drop off in evidence as it relates to these court proceedings that appears reasonably designed to put them or likely to put them in a bad light, or to get them fired, or to have them suffer negative consequences as a result. We know providing copies of unsolicited documents, personal letters, court pleadings, emails, texts to anyone associated with the party, their significant other, family members, neighbors, employers, etc., for the intended purpose of shedding the other party in a negative light. None of the parties shall post, nor shall you allow significant other or family members to post on social media, including but not limited to Facebook, Twitter, YouTube, Instagram, LinkedIn, Tumblr, and Google+, any negative or disparaging allegation against or negative image of the other party or anyone associated with that party. Pursuant to EDCR 5.301, you will not discuss any of the court issues or proceedings with the minor children, including showing them any part of the pleadings or attachments or exhibits, including audio and video. You will take every precaution to secure copies of pleadings safely away from the eyes of the children at all times. This means all evidence of litigation generated on your side and from the other party's side. Neither party shall interrogate the children as to the activities or events at the other party's residence, etc., and shall try to respect and not interfere with the children's privacy and relationship with the other party. Do not place children in a loyalty bind between yourself and the other party. Your children need to be able to love all of you freely in both of your homes for healthy child development. Neither party shall interfere with the other party's contact with the minor children, including but not limited to telephone, email, social networking, contacts, etc. Neither party shall threaten or to commit or actually commit an act of violence upon the other party, upon the children, or upon the significant other, friend, relative, employer, employee, neighbor, etc. of a party. Child custody exchanges, visitation, etc. shall be done in a civil, law-abiding manner and reasonably close to the time specified by the court. In the event of an emergency or unforeseen circumstance that could affect an exchange of the child or the time of the exchange, a party shall call or contact the other party as soon as reasonably possible. In the event of an emergency or unforeseen circumstance that could affect an exchange of the child or the time of the exchange, the party experiencing the emergency will contact the other party as soon as reasonably possible. Also, there shall be no spoliation, destruction, alteration, or modification of electronic evidence such as emails, text, social media of all forms, or voicemails, audio recordings, video recordings, phones, iPads, etc., with any information that either party or the court may deem relevant to the current court proceedings. There shall be no invasion of the electronic devices, email accounts, social media accounts, separate bank accounts, safe deposit, separate residence, or separate vehicles of the other party. except as modified herein, all other court orders remain in full force and effect. And the parties are put on notice that violation of this order, if admitted to or found after an evidentiary hearing to have committed an act that violates the order, may result in the party being held in contempt of court pursuant to NRS chapter 22, which could result in a fine of $500 and or up to 25 days in jail and or attorney's fees for each violation. So that should be the full inclusion in the mutual behavior order. Want to do that as a separate order. Mr. Dwiggins, I'm going to have you do that and provide it to Mr. Houston to review and sign off. He can have a week to do that. If you don't respond or anything, they're going to send it to me. We'll check it and go from there.
And I just need the minutes to be posted, so I didn't have time to jot all that down.
Yes, and you might want to get the video. It might be the better, because my court clerks can't put all of those words into the minutes very well. The minutes are supposed to just be a summary. Let's see what else. So are we going to go forward with contempt proceedings? I have mixed feelings about that, but the pages have made a prima facie case on violation of the January 30th, 2025 stipulation and order with certain provisions we've talked about.
Your Honor, may I speak?
Sure.
The only reason we want to do a contempt of court is to have him stop his behavior. But I think this should have been done a long time ago, this behavior order, because with his past history and how far this has been going on for 3 years or 4 years with Ashley, and then it went to this, and now we're still here. We're still at the same spot with his behavior. That's why I have, so I don't know if the contempt of court is going to do any good. I understand your position, and I believe that's what I want, the best interest of the kids. But we're here at the same thing from his behavior. This is the same messages that we've been getting, not necessarily us, but actually for years. So I don't know how to stop it. I don't know. And the kids are suffering. And I understand you had to do a behavior order on us for keeping everything the same, but there's no reason we even need to have one. I understand when you did it, because we are not doing any of this.
Well,
There's not been one,
There's not one instance.
there's not one text message, not one phone call, not one
No,
email,
no
not
one
one
disparaging
anything.
thing that we never said anything about to Emma or Jack about the father. No
And
one.
we put Dylan recently in her iPad so she can contact him during the week.
And his story about he takes a couple days to get the kids back in order is a complete lie. He's talking to them Sunday night. There's never been an instance where the kids have, once we drop them off, we drop them off. There's no other behavior. There's no different behavior. We're doing
I don't know
everything.
how I
we
can
can.
make
there's
that
different
statement about what
schedules
goes
in
on
each
in my
house,
house.
hold on. This doesn't mean it's negative towards anybody, but there are different schedules and stuff. Adjustment periods are normal. The parent, when you have custody between a parent and parent, they're gonna experience adjustments. And because we're doing a week on, week off schedule, which has some advantages in this case, but they're pretty young to do that. It probably does take a few days to get used to. There's different household rules, different expectations. All those things are normal. But what I'm concerned with is, on your side is that I agree with Dad that somebody, if these were actually sent by somebody on your side, I don't know.
Well,
It-
we welcome that somebody researches it.
Please just
Yeah.
do an investigatory, whatever you have to do, go to Metro, whatever. It was not us.
Not
Well, and
anything.
I certainly would say, I know Miss Wiggins says that's not akin to a death threat, but if I had sent a message saying keep your head in a swivel, we would have been in here in an instant
But you
saying
can't
that
speak-
was a death threat.
It-
We're speaking to each other.
Okay, I get it. I can't fix everything here. All I can try to do is help you guys stay out of court, first of all, is my goal, and do what's best for these children. And that's to protect them from as much of the nastiness in the adult world and nastiness in their lives as we can until they get older, till they have tools through counseling to understand the stark reality of what happened to their mother, that happened to their grandfather. These are hard things for them right now understand, and there's gonna be hard things for them to deal with once they can understand what happened. They're gonna have questions. They're gonna want to understand how this situation happened, but right now we need to protect them. They're 5 and 7. They know what they need to know is that their grandmother, or the grandfather and their mother, and their stepfather are not with them anymore. So they don't need to know that. I won't let them, you do the same thing, but I can't be in either of your homes. I can't be there and say, I have to get you to buy in and say of your own self. Whatever it is that I feel about the other side, I'm not gonna share it with my children because I'm not gonna share it with my grandchildren because that's not appropriate for them. And you guys have every right to have the feelings that you have. There's a lot of history here. But you don't have the right to use your children as weapons against each other. You don't have a right to hurt them on that. I mean, I thought about playing the video in court, but I don't want their faces being shown on the internet.
I agree with that, Your Honor. I just thought it was worth you seeing.
Yes, and
Because it is very disturbing.
I read the quotes from it. The reason I thought of playing it was so that you could see it, Mr. Houston, and try to look at it from an objective point of view. If that was happening on the reverse side, what would you think?
Well, it certainly had nothing to do with interveners. They dispute that, but,
Well, you send it to them. What was your purpose in recording it and sending it to them? In the middle of the night?
I send them videos and pictures often, actually, so.
Well, in the context of all of the text messages you wrote, I mean, you have to understand that you look in a very bad light in doing this. There's no other way for me to.
No matter what I do, they're gonna think of me in a bad light. That's.
No,
admitted.
objectively, I don't think that what you did is good for your children. And my job in this case is to try to limit their harm. And to let them love everybody. So,
Well, I've certainly fostered that relationship between them, the interveners, and my kids, even when Ashley was withholding the kids from them. So this thought that I all of a sudden that day decided I wanted to turn the kids against the interveners is not true. It's just not true.
okay, well, I can tell you that that's what it looks like. So I'm not gonna order you because counseling for adults doesn't work if it's ordered. You gotta want to change, you gotta want to see, hey, there's areas where I can behave better, be a better person, be a better father. You've gotta want that. But I would recommend, if you don't already have a counselor, to be in counseling and work on that. Become the best father you can be for your children, because this is not okay. It's not okay to do that. And I would say this, if the pages were doing these kind of things and denigrating you to them, would not be okay either. You're their father, you're always gonna be their father.
They did it on national television, just not to my kids.
But your kids weren't watching that. And there's also a context to it and a time and a place for them. They're probably, you're right, it's all out there. At some point in time. And kids younger and younger are learning how to use the internet and get these smartphones and use that stuff. At some point in time, they're gonna see that, but not today. So we shield them as long as we can from that.
Your Honor, may I request still, and I hear what you said, but order him to go to counseling, because as I'm sitting here listening to him and what you said about his lack of maturity, lack of awareness, his impulsiveness, he is taking no accountability for any of his actions, and he thinks it's a joke. And I'll tell you, he's probably going to do the same thing he did to me last week after the hearing, is brag that he won at the hearing because he got what he wanted. Because there's no consequences to him. When he sent me an email about my lackey, which I took to mean my associate, and I asked him not to gear his anger towards me because of the hearing, and he said, I don't know what you're talking about. I won and got what I wanted.
Your lackey was Dr. Fife because you're in cahoots with her in this case.
Keep speculating all you want.
Mr. Houston. Again, you just
Doesn't.
are not seeing how your behavior and words seem to other objective people.
Well, that's walking the
It
fine
shows
line
a
of
lack of
counselor
maturity.
and being personally involved in this case. So that's a unique circumstance in this case that I don't have to deal with in other cases where I'm representing clients.
You know, I can give you time to think about whether you want to do that. I can set an evidentiary hearing and you can vacate it if you want. You're entitled to go forward on contempt. I don't know. I don't have a crystal ball.
Let's
They don't
do that,
issue
Your
them
Honor.
with that, is whether it will help or not. If, I don't know whether you're gonna be able to approve the contempt, but you're entitled to the chance. And then if you do approve the contempt and I do sanction him some way, I don't know if it's going to change his behavior. I don't know if it's gonna change his feelings. But you're entitled to that. So if you want me to set it, I have dates on,
Let's
Just-
go ahead and do that, and then we can vacate it once I have an opportunity to discuss it in more detail with my clients.
right, like everything in life, there's pros and cons.
Of course,
There's definitely cost and stress of going to court. I have December 10th or 11th. That's a Wednesday, Thursday. I think you guys could finish in half a day. The issues are not many instances. Some of the evidence is not in dispute either. Because I
think you're
did
right.
not hear it, Mr. Houston. I did not read anything in your opposition that you didn't send those text messages that were attached.
Nope, I didn't say that.
Okay, so
The
Tell me.
10th, I have a mediation in another case.
I'm sorry, I'm having trouble hearing you.
Sorry, on the 10th, I have a mediation in another case.
Okay. What about Thursday, the 11th? If we start at 9 o'clock? Hopefully we can finish by lunch. I'm not gonna set a calendar call, but I will give you, because that's a pretty shortened time, I will give you until November 24th will be the discovery cutoff. And then if you can file any pretrial memos you want to by November 26th. Actually, let me give you till, you could wait till December 1st to do your pretrial memos if you want to do any. Pretrial memorandums are optional, but if you want to submit them, that'll be your deadline to do so. Any other witnesses you want to use, I'm going to have you disclose by November 10th. Because I'm doing this on a shortened matter. It's hard. My normal cutoffs and deadlines would not work. So if you want, Mr. Houston, if you, either side wants to have other witnesses besides the parties testify, we've got to designate them in writing by November 10th.
And I can take a deposition of Dr. Fife before then.
Yep, if that's what you want to do. Discovery is open on that, and discovery, like I said, will cut off on November 24th. And pretrial memorandums, if you're gonna file one, are due the December 1st. And then submit any exhibits ahead of time, either electronically, because you're gonna have trial management order. So that'll give you the instructions on how to do that electronically if you've never done that before, Mr. Houston.
Yeah, I would need,
Submit those by, because it takes time, by Friday, December 5th. Get your exhibits either over in hard copy or electronically, so we can have them pre-marked and stuff. Anything else I need to order today that I didn't address? I'm deferring any request to attorney's fees, because the attorney's fees, if awarded, would be in relationship to the contempt.
Your Honor, we could let the court know and Mr. Houston by September 19th, which is next Friday, whether or not we intend to proceed before either party undergoes any expense. I just really want the opportunity to discuss it in more detail with my clients versus just whispering here at the council table. And I do know that the children are scheduled for therapy tomorrow. I would just ask that perhaps for the next 60 days, that instead of going every other week, they go once a week, because I think what has been done has harmed them. And what?
I don't think I should be required to take them past September 30th, which was the previous order of the court.
I'm not gonna change the previous order because I think it'll be counterproductive. Not because you don't have legal merit to the argument, but it's a matter of being as productive as we can in therapy. So the children are this week are with dad.
Yep, so we're going tomorrow, and then 2 weeks from today is my last day taking them.
Okay,
Well, I hope tomorrow's therapy session isn't going to be a repeat of last one in which he took them.
All right, so what I'm saying is the interveners can file, if they don't want to go forward, file a notice that you're withdrawing the request for the order to show cause and serve it on Mr. Houston, so he knows that there's no need to discovery. We're gonna vacate the trial date, et cetera. And what
I
else?
could do that by September 19th, Your Honor.
Okay, that's next Friday,
Yes,
so he'll know whether he needs to conduct any discovery to defend himself on that. And you'll need, if you're going forward, you'll need to do a specific, more, order to show cause again.
of course, Your Honor.
So, and then, as soon as you're drafting the mutual behavior order,
Yes.
do you think we need another order? I mean, we need an trial management order, I'll do that. We need the mutual behavior order done separately. And the order shall cause done separately. Do you think we need another order from the hearing today?
I would say so, denying the injunction and anything else. of
All
that
right,
nature.
then I'll have you draft that, Mr. Houston, and provide it to Mr. Dwiggins at her office that they can review and sign off. Anything else today?
No, Your Honor.
All right, thank you all.
That's it, thank
Your
you.
Honor.